All right, Representative Villio on House Bill 479.
Thank you, Mr. Chair, members. House Bill 479, Transparency in Sentencing. Mr. Chair, I believe there's an amendment relative to the Miller defendants. If we could offer that amendment, if someone could offer that to put it in its proper posture.
Hold on,
Sure,
Representative.
I can.
Does
Thank you.
someone have them?
I think they're looking for it. That's the problem.
Hold on one second. Mr. Lambert, is that the one?
Yeah, we sent it to staff last week. In essence, it reinstates both the parole mandates for Miller defendants, Graham defendants, and compassionate release.
Okay,
That's all.
let's give staff a few minutes, and let's Representative Villio discuss the amendment. I mean, discuss the bill.
Absolutely.
In the posture of the amendments being adopted, and once staff has them prepared, we'll get them on the bill.
Mr. Chair, members, let me start by saying what transparency in sentencing will not do. Transparency in sentencing, if done correctly, is not intended, nor will it likely increase the incarceration rate. Simply put, it's not intended to fill up the jails. Felony sentencing with good time calculations, parole eligibility, old-timer parole eligibility, early release for the completion of programming, transitioning programming, and habitual offender procedures are complex. Ms. Laborde today confirmed that very point. Victims and victims' families generally don't know the release date of their offender. Defense attorneys sometimes have difficulty in advising their clients on pleas based upon the difficulty in calculating a release date. We repeatedly hear that certain felony offenders serve time beyond their release date. As of December 2020, the Department of Justice is investigating the Department of Corrections for this very reason. The Department of Correction and the state faces lawsuits and damages for holding offenders beyond their release dates, and the complex sentencing schemes are at the heart of this issue. What transparency in sentencing does do? It removes all ambiguity and applies uniform sentencing to all offenders and affords victims security in the information to which they are provided. It is intended to let everyone know what to expect in sentencing before a plea or when the judge's gavel hits. It will allow probation officers to devote time to probationers and not parolees, and thereby also reducing recidivism. I welcome any questions, and I have Mr. Lampert here to also speak on the bill.
Mr. Chairman, members, Lauren Lampert, Executive Director of the Louisiana District Attorney Association, and Representative Villio, the author, explained the bill in both in concept and detail. And as you might have heard, many of you have gotten the calls, this is to reverse all of what JR did. It is absolutely not. It's to build upon what justice reform did in 2017. We busted the bottom out of Pew's predictions for 10 years in less than 9 months. We're now at about 26,500 from our almost 40,000 high water mark. And we have no desire to increase that unless crime increases, obviously. We think crime should be the driver of the incarceration rate and nothing else. And this is not designed to increase that. We understand that there are some concerns, and we're willing to meet those concerns head on. But what you'll hear here in just a few minutes is not only are victims completely misled and with the complex or enigmatic early release mechanisms that, quite frankly, the DOC lawyers have difficulty interpreting, and so do criminal defense attorneys and prosecutors and judges. Defendants don't know what their dates are to be out, but victims are re-victimized. I mean, there will be a number of truthful testimony here about people seeing a judge bang the gavel and give somebody 10 years, and then less than a year later they see them in the Walmart grocery line, and they don't understand that concept. So Transparency in sentencing clears that up. It, in and of itself, will cure almost every problem that House Bill 603 you heard just a few minutes ago is intended to address, and it does it more surgically, and it does it as a significant cost-saving measure by reducing the supervision of those good time releasees, and allowing probation and parole basically to cut their supervision numbers in half. They can then do exactly what you intend them to do, that is to prevent probationers from ever going to prison and prevent those with split sentences from ever returning to prison. So with that, I'll answer any questions.
Thank you. Let's pause for the questions and allow Mr. Riley, because the amendments have been posted online. So let's have Mr. Riley explain the amendments, and then Representative Villio can move to adopt the amendments.
Yes, members, they are being handed out, the hard copy, but it has been online. It was submitted. And what the amendments do, they both occur on page 3 on the end of line 19 and the end of line 24. It creates an exception in those two with respect to parole eligibility with juvenile offenders and parole ineligibility. It says those persons who satisfy, except for those persons who satisfy all the provisions of subsection E of this section, and subsection E are those provisions that talk about the juvenile offenders and they've served the 25 years of sentence and those conditions that you are familiar with. It exempts those people out of these provisions in both cases.
Thank you, Mr. Riley. Exactly. That's the Miller defendants we talked about, as I remember, last week in Criminal Justice Committee. And so obviously the amendment is intended to exempt those persons out from this bill. And Mr. Chair, I'd offer that amendment.
Thank you. Representative Villio has offered of the set of amendments. Any objection to the adoption of the amendment? Hearing none, the amendments are adopted. I'll turn you on. Representative Marcel for a question.
Thank you. Representative Villio. Let me see if I understand this correctly. You are changing the good time, basically, of people that are convicted. Is that accurate?
I think the bill in its current posture arguably does that. Because it has, if you're talking about the percentage at 85%, I believe currently it's 75 and 65, depending upon the class of defendant. And obviously I'm committed to working with this committee and the body on any changes that are necessary. That, quite frankly, in my opinion, was a starting point for this bill, and certainly subject to reasonable discussion.
Okay, so let's have the reasonable discussion. If we're changing the good time and we are decreasing the amount of days that they can earn on a second offense for a violent offense, wouldn't that increase the time that they're in jail? I mean, it's simple math to me.
Yeah, I'm going to let Mr. Lambert.
If I could, you're exactly right. The good time rates are increasing from 35% on nonviolent to 85, and then from 75 on violent first offense to 85. So it's 85 with a violent offense, sex offense, nonviolent offense. Now, to answer your question, in and of itself, if the sentence remains the same, that's a non-starter, right? It does increase the amount of time somebody has to serve. The judges that we have in other bills in this committee lauded the discretion, and now know that if I want somebody to serve 2, I give them 2 instead of 10 to get them to serve 2.
Well, every judge is not going to use that, though, as you know. The exceptions that the law currently have in it, removing those exceptions, why do you think those exceptions were put in there?
Well, those are going back in, actually. So the amendment,
You're gonna put
the amendment put those
The
back
amendment
in.
put those back in there?
Yes.
Okay.
Yes, Representative Marcel, that's exactly why we put it back in.
Okay, the final question. Do you have a fiscal note on this? What would it cost us fiscally?
I believe there is a fiscal note on the computer.
What's the
if I'm
fiscal
not,
note?
mistaken, but it actually will decrease the cost overall. And what you're looking at, Representative Marcel, one of the benefits too of this bill, of the many, in addition to the many I've discussed, is then you will have parole officers who are monitoring their probationers instead of monitoring
Will
parolees.
we have less parole officers
I think
as a
over-
result of this?
I think over
People
time,
lose jobs?
that's absolutely not the intent, Representative Marcel. And keep in mind that it's going to take years. Obviously, this is intended to be prospective, not retroactive. So over time, you're going to have, by attrition, you would be able to manage that employment. But over time, you would have parole officers who currently supervise probationers and parolees, then supervising the probationers in a more meaningful way, in my opinion, which would also reduce recidivism. But this measure will result ultimately in a decrease in costs and not
So
an increase.
your thought process is it's going to reduce recidivism because parole officers will have more time to deal with people that are not incarcerated? Is that what you're saying?
I think there's some studies that certainly show that based upon a certain amount of good time.
What about additional programs? If we would give them additional programs, when and I'm gonna say this because I know I'm out of time. A lot of times when they're going through the programs to get the good time, it's not just they just get it. Sometimes they earn degrees and certificates so that we could help them to get out and get on their own.
Absolutely.
You don't believe that if the time is decreased, the good time that they have, instead of them getting out early, you don't think that they would not utilize some of those programs and thereby actually increasing the recidivism rate? I would see it as going the other way.
I do think the program is important, and I'm going to let Mr. Lampert answer it for you.
All of that stays in place. The CTRP, the 360 days additional earned, and all that's explained to the victims up front. We want to encourage that. And in fact, we're supportive of a bill going through the system right now to increase that for those who earned college educations. That's earned time off. Good time is kind of a misnomer. It's not earned. It can be taken away if you don't act right, but it's never really
But
earned.
we do want to incentivize people to act right, don't we? I think the wardens would want them to act
We
right.
do, and we do. So that's why there is still a good time piece in place. It's just normalized across the board.
It's just less good time.
Yes, but the things that you're referring to, the programming that we all agree is necessary and productive,
Yes.
remains in place, and they still get additional credit for that.
I'm out of time. I just don't want to see us go backwards from what we've worked on in the past, and I just don't see the need for this bill. But thank you.
I assure you, Representative Marcel, it's not the intent to go backwards, and I'm committed to
Thank
working
you.
with each of you.
Thank you, Representative Villio, my friend, and I'm not going to invite you to any apples today either.
Please, but peaches, grapes, pineapples are great.
Thank you, Representative
Thank you.
Marcel. Representative Marino.
Thank you. We've had a bunch of seat discussions already with my seatmate about what I think. I think if we're going to look at how much time you serve for all different offenses, and we're not at the same time looking at sentencing for all offenses, this bill is reckless with regards to what could happen if we only talk about time you serve and not sentencing and sentencing ranges at the same time. Because even if you talk to judges and say, Judge, if you give them this much, they're going to serve 85, not 35. If we're not looking at mandatory minimums and sentencing ranges on everything, because y'all are raising the sentencing time on violent offenses too, not just nonviolent. So if we're not doing these both at the same time, this is very dangerous and reckless with regards to how we're going to potentially double the jail population, because the judge doesn't have to say, I'm going to recognize that and I'm going to give them lower. We still have the same caps way up there. A judge can give you now way more than double the amount of time. It's just reckless. And I think that if we're going to do it, let's do it all at the same time. And this is not a cure-all for transparency. But I want to save my time, so I'll stop talking.
Save 15 seconds.
I got it.
Representative Bacala.
I'm just trying to get a handle on, here's what I think is, what this bill does is we're reducing the amount of good time, but we expect that the sentences will be reduced accordingly. So that maybe somebody who would, under today's system, get 10 years and expect to get out in 5 would get 6 years and get out in 5 and be subject to less parole restrictions or supervision.
Exactly. And Representative Bacala, if we go back to last week, and Representative Jones' bill that this committee considered on habitual offenders. And what we said last week, essentially, when we passed that bill out of committee, is that we trust the judges and their discretion in sentencing. And so that's exactly what we're saying here. But what it does is it affords the offender, it affords the offender's lawyer, it affords the victim, it affords DOC, it affords everyone a certain, consistent sentencing scheme and time period, and still doesn't take away the exceptions we talked about, and still doesn't take away the programming that's available to these individuals to incentivize them while they're in prison.
And I'm noting that this only would apply to offenses that occur after August 1st, 2021, which probably means it wouldn't apply except for trials at, I don't know, January 1st, 2023, correct?
I'm not
I
sure
mean, I
of the
don't know
time
how-
frame of when those trials will begin.
No,
But yes, you're absolutely correct. This is not retroactive, so it will only go apply to individuals. So that's why I said, it's a project in terms of, or a process in terms of years before you actually start
Would a
implementing.
component of the bill, I think, would perhaps be helpful if it also included a piece to require judges to receive some degree of training in the new statute, how it should affect their sentencing behavior, so that they need to know that this is going on, that a 10-year sentence now, a 6 would be the equivalent of a 10 if this is enacted. I think it would be very much necessary to make sure the judges understand that a 10 would be an 8, and currently it's a 6, unless they adjust sentences accordingly.
I think it's a great idea, Representative Bacala. I certainly would have no objections to that. And again, I'll say it till I'm blue in the face that I'm committed to working with this committee and every member before this bill would ever go to the House floor.
Yeah, I don't know if we'd want to recommend or take some other consideration in, but they would have, this only works if the sentences are reduced proportionally, right?
You're exactly right, and 22 states have this, and the federal government. The best model we found is Florida. They were able, when they went to this, they were able to reduce not only recidivism and crime, but the incarceration rate as well. So there is a way to do that. You got to be intentional, and you're right. An educational piece through the Judicial College is a really good start. But and Rep. Moreno was correct as well. We have to be intentional about being honest with everybody. And that is, if we want somebody to serve 2 years, then let's give them 2 years, not 10, as we currently have to do. And ultimately, we will be better off. And we're committed to not repopulating.
The other piece that's not recognized in this is we have a lot of benchmarks that occur upon the completion of sentence of incarceration, which has been defined as the day you get off of probation or off of parole, right? So 10 years after you're off parole, then you have the eligibility to vote. This would also take that 10-year period and mark it back to 6 rather than mark it back to 10, because you're going to be on parole for the remainder of your sentence. So if you're sentenced to 10 but you get out in 7, you got to do 3 years on parole and then wait 10 more. But if you cut it back and you say we're going to give you 6 instead of 10, but you're going to serve 5 or whatever the number is, then you're off parole sooner, and those other things kick in quicker. The parole ends sooner, voting rights kick in sooner, etc. Is my reading that right?
It's a finite date, so you are reading it right in that sense.
Okay, I appreciate it, and I think if we could insert in the piece that would compel or at least influence judges to modify sentences based on these new criteria, I think it accomplishes a lot. Thank you.
I'm committed to working with you on that language.
I'll let you work on it by yourself, but I know you I know you understand the point, so I don't need to. I know you will.
Representative Marino is shaking his head, and since he said I was reckless, I'm sure he'll want to help me
He's your seatmate. He's your seatmate. Y'all can talk about it plenty.
all the time.
I could only imagine the conversations that you two have over there.
I think he liked it better when we had the barrier between us.
He said it's going back up. All right. We have a few more people that want to speak. Kathleen Barrios, East Baton Rouge Parish District Attorney's Office. And Zachary Daniels, 21st JDC, Livingston. And W. Claire, what is this? Is it Harrington? New Iberia.
Mr. Chairman, may it please the committee, my name is Zachary Daniels. I'm with the 21st Judicial District Court. For the sake of expedience, two other witnesses speaking in favor are actually with me, Ms. Tomlinson and Mr. Roberts. Would you allow us to call them up in that order? Because my main purpose here is to introduce them.
Okay. So we have Ms. Roberts. What about Ms. Barrios? She's hometown, so she you should have let her come first.
No, Ms. Howington and I would like to speak together.
Okay, good deal. So we'll give deference to Mr. Roberts and Ms. Tomlinson.
Just to briefly inform the committee, as I said, my main purpose here is to introduce the two people sitting next to me today. I was introduced them, unfortunately, through a person named Michael Ferris. On October 2nd, 2015, Mr. Ferris chose to drive. Now, ordinarily, that's not a violation of any sort. He had a license at the time, but he chose to drive while under the influence of opiates. He was driving in broad daylight shortly after noon north of Denham Springs within Livingston Parish, and he crossed over the center line. It was a clearly marked road with rumble strips. If you're not familiar with what those are, it's what you hit on the edge of an interstate that gives you a physical response as to why you should stop your car. When he crossed the center line, he did not crash his vehicle alone. He crashed his vehicle into a 19-year-old's vehicle named Miranda Roberts. Ms. Roberts did not survive that accident. There is an insult to injury component to that death. The death alone is a catastrophic loss for any family member, and the people sitting beside me are the parents of Ms. Miranda Roberts. The insult that came with that injury came after their introduction to the criminal justice system. Mr. Ferris chose to go to trial, and part of that was motivated by his criminal history. The insult was added when it was discovered that he had not 1 or 2 or 3 DWIs. He had 10 DWI convictions and at least 18 DWI arrest entries on his criminal history. So at the time he was adjudicated, he had multiple felony convictions, not just for DWIs, for other offenses as well, and he had taken the life of a citizen of our state. The judge took all this into account after the state proved he was guilty beyond a reasonable doubt of vehicular homicide. The judge sentenced him to 20 years in the Department of Corrections, and at a certain level that did not seem enough. The second insult that came in this situation was the notice that was received by the family members that he would not serve 60% of that 20 years. He would not serve 12 years or 10 years or 8 years. He's going to serve about 5 years in the Department of Corrections. As I sat down with the family to prepare them for trial, prepare them for the possibility that we might lose, prepare them for the possibilities that at sentencing we might not get the number that we would want. And while no number could replace Miranda, I at least hoped to give them a number that they could feel justice was done. Unfortunately, they heard 20 years and he's going to serve less than 5. When they asked me how long he would serve, I'm unable to answer that question. For defendants, for victims, for anyone in the courtroom, the defense attorney, the prosecutor, and the judge cannot answer that question. With that, the insult and injury was completed, and I asked them to appear before you to talk about this. They're aware that this change in law, this truth or transparency in sentencing, will not keep Mr. Ferris in jail longer. They are before you today because the impacts, the decisions you make in this committee impact real lives. And I would like you to hear from some of those citizens. Mr. Roberts, if you'd like to go first.
She's got a prepared statement. I'll let her.
Thank you, Zach. My name is Laura Tomlinson. Most of my friends call me Jeannie. I thank you for allowing me to come here to speak today. I'm going to read my statement as I'm nervous, and this brings up a lot of painful issues for me. So I'm just going to read what I prepared. I'll give you a little background information. A lot of this is just going to be what you just heard. Why I'm here today. On October 2nd, 2015, my daughter Miranda was killed by Michael Ferris, a driver under the influence. It was the middle of the day and she was headed to work. She had her whole life ahead of her, but on October 2nd, Ferris chose to drive while impaired and intoxicated. That day was his 11th DUI. Assistant District Attorney Zach Daniels fought to get the conviction of Ferris. Judge Morrison found him guilty and sentenced him to 20 years hard labor with the possibility of parole in 3 years. With a guilty verdict and 20-year sentence, it felt like a victory for us and justice for Miranda. That feeling was short-lived. A few months ago, I'm not sure how long because I don't remember things the same way as I used to. It's called grief brain. Anyway, I'd called the DOC because I had not gotten any information on Ferris regarding when he could start to apply for parole. In that conversation, I learned that even if Ferris was denied parole, he would still be released on 11/18/2024, which is my daughter's birthday, by the way, but also would mean he would only be serving 6 years for killing her. I can't begin to explain the shock, devastation, and anger I felt that day. I was at work when I made that phone call and received that news. I felt like I'd been punched in the chest. What was the point of countless court appearances, continuations, and a trial? Was it all for show? These were all questions I was screaming in my mind and asking my husband just why. Why hand down a sentence that would never be completed? Where is the justice for my daughter? Is this the kind of message we send to the residents of Louisiana, that it's okay to repeatedly get DUIs? How can vehicular homicide not be a violent crime? She was killed. He caused blunt force trauma to her head. He caused multiple organ failure. She had a lacerated liver and spleen. Do you understand? It is difficult being here today to discuss this all over again. It's breaking my heart all over again. This is why this bill is so important. I don't want families to have certain hopes and expectations, then be devastated when it doesn't happen the way they expected. There should be transparency across the board. I hope with the transparency and sentencing bill being passed, my faith will be restored in the justice system. I don't want another family to endure what we have. I want families to know exactly what a sentence means and for how long. Michael Ferris robbed my daughter of her future. She will never get to go to college, become a wife, and a mother. The DOC robbed her of her justice by not fulfilling the sentence handed down by the court. I've prayed you make the right decision. Thank you for your time.
Thank you, Mr. Robert.
Thank you for your time. A lot of what I would have to say would be to reiterate what Zach and what Jeannie has said. We were robbed. Our daughter was robbed, and we don't want to see future victims to feel like they were robbed. When a judge hands down a sentence, we would like it to be, 20 years is 20 years, or good behavior, whatever. The man that took our daughter's life, that was his 11th DUI. He had chance after chance after chance. He doesn't deserve good behavior release. He deserves to do his 20 if he lives that long. There's a lot of hurt, there's a lot of anger, and we don't want future families to have to get a phone call and say, oh, well, he may be released this early, not even serve 50%. And so that's why we're here in support of Representative Villio. And that's all. Thank you.
Thank you. I want to ask some questions, but I would, that they're probably going to seem very, very insensitive, but I'm not. I want to know how that guy was able to have 11 DUIs. Like how many deals was he given before this situation? Like what happened? Like tell us the complete story.
Sure. I can't tell you his complete life story. As a
I don't need his
prosecutor.
life story. I want to know the stories about the 11 DUIs.
Certainly. Stretching back, and if I can pull it up on my phone, I will try to do so while speaking, Mr. Chairman. His DUIs actually stretched back longer than I have been alive. Beginning, and it might not surprise people, I tend to look young, but beginning in November of 1977 with Decatur PD, which I believe was in Alabama.
Out of state.
Yeah, out-of-state DWI, out-of-state DWI, coming back into our state probably in a time period where electronic communications did not allow jurisdictions to inform each other that there are these repeat offenses, and prior to some of the steps that this body has taken in terms of increasing penalties and our awareness of the dangers of intoxicated driving. Continuing through the 80s, he began to get felony DWIs in our state, and then again, as he is released in our state, paroling out, he is returning to other states or moving out of state to again commit felony DWIs there. As I stated, they're not the only type of DWI he had. He also had controlled substances convictions here. And his final felony DWI occurred long enough apart from prior ones. Obviously, the cleansing period on DWIs is not like a felony with habitual offender or the possession of firearms. It does not restart. As DWIs age, they age permanently. They don't stay alive, even though we see someone continuing to repeat the behavior uncorrected despite repeated jail sentence, despite repeated opportunities. The story you're hearing is the fact that he probably should have been held to more stringent penalties than he was, and we were unable to do so. I think the transparency in sentencing would allow, when a judge finally does see, and unfortunately it took someone's life being lost, a judge finally sees this person needs to be in prison. This person has been given opportunities. This is not a first offender. This is not a juvenile offender. Given opportunity after opportunity to correct their behavior, and now cost someone the ultimate price. And the judge's final word isn't the final word. A bureaucratic body then takes control and determines when his release date should be. So I would kind of voice Representative Bacala's comments that a lot of the sentencing is no longer in the control of the judiciary. The separation of powers has been blurred where it comes to the administrative determinations of parole and parole eligibility. And I note that Representative Marcel is not here, but good time is a misnomer. Good time is awarded to everybody in an effort to get them out. And it unfortunately is going to mean that this person is going to serve 5 to 6 years instead of 20.
Yeah, but I mean, it's something to be said. Like there was some other folks that made a decision to grant some leniency on that guy those other times, and that person was probably somebody in your position, not the judge. It was probably DA that probably offered some type of deal or something, And I mean, I know that it kind of. I just like the complete story to be told in here, and that for somebody to have 11 DWIs, like either he had a phenomenal defense lawyer in all these different states, or he had a district attorney that was too lenient when he should have been. So I mean, I'm about the whole story. So I get that their story is very tragic, but there should have been something that stopped that person from still being able to drive, and that's not just the fault of a judge, or that's not just the fault of the laws. There's also some culpability that should be had with the folks that were prosecuting those other cases.
Certainly, and I think his last DWI that I was able to find for a conviction ended up being a misdemeanor based on the cleansing period. I believe he was given the maximum sentence on that, and as Representative Marcel adequately pointed out, you don't need a license to drive. So even any efforts by anyone in my position or any efforts by anyone in your position in terms of suspending licenses, it clearly nothing was going to stop this person from driving drunk except being in prison. That appears to be the only time he was stopped from driving intoxicated, and it fell short in this position. A DWI fourth, had he even been convicted of that in the last 10 years, it would have been a 25% parole calculation.
I got you. All right. Thank you.
Thank
Do you
you.
have any other questions? Ms.
Just one more
Barrios,
thing, if I could, I'm sorry.
Sure.
And actually, he was driving 6 months after he killed our daughter. He was given his license. It wasn't that he was driving without a license.
He was driving himself to court.
Yes.
So,
Wow.
Because we had 2 years worth of hearings before we actually had a court date, and he was driving himself to court.
And he was under the influence when he testified in court at his own trial, so.
That
Yeah.
would be accurate.
Yeah, I mean, and that seems like somebody that we're not going to legislate morality. We can't do that. And that, like you said, if any place outside of jail, he would probably been harmful to someone. So
I would ask you to help us keep him in jail where he should be. Thank you.
Good afternoon, Mr. Chairman, members of the committee. My name is Kathleen Barrios, and I am a prosecutor in East Baton Rouge Parish. I have been a prosecutor for nearly 12 and a half years, and I hate that Representative Marino has left the room because in 2017 to 2018, I, as well as Representative Marino, several other 88...
He's back.
Several other criminal defense attorneys, public defenders, retired judges, civil practitioners, we served on a legislative task force. And the goal of that task force was to create a clear and regular and transparent sentencing regime for the public. I apologize that I'm having a little hoarseness. And the DAs obviously agreed that a felony class system was the way to do it. But we all agreed on one thing, that it was these back-end sentencing measures that created confusion. And I want to share with you some of the notes that happened during that task force. Mr. Scott Nettles, who worked for Manasseh Gill, a private firm, said the question he hears most from defendants and their families is how much time is a defendant going to serve in jail? And Senator Claytor, who was on the committee said that the only way to even ascertain the answer to that was to call Henry Goins, who's now retired, and ask how much time someone's going to serve. The Secretary of the Department of Corrections even testified that he would be unable to explain to us how to compute sentences because it was just too complicated. And that's what this bill does here. And I want to share with you all some things that occur in court, and I think will hopefully address some of these issues of, adjusting the sentencings. So, for example, some of the plea agreements that I've had to enter into cases involve felon in possession of firearm, a violation of 1495.1. If I want someone to have to serve in prison somewhere between 5 to 8 years, that's a 20-year sentence that the court needs to impose. A conspiracy to commit manslaughter, 20-year sentence, someone may serve somewhere around 5 years, 7 years, 8 years. Most recently in court, we had a defendant who was being sentenced to 1 year suspended, and then being placed on 2 years of probation with special conditions. And he turned to his attorney during the plea and said, so I don't have to do any of that, right? If I just go back in and I'll get calculated. Because he knew I'm only going to have to serve somewhere about 25 to 35% of this year. If we had actual truth in sentencing, we would know what a year meant. We would know what 20 years meant. And if I wanted to accomplish a plea agreement where the person was going to serve approximately 8 years, then we could sentence someone to 8 years. And victims would not be deprived of transparency in sentencing and what it actually means. And Representative James, I want to address something you said about, this person had fallen through the cracks. Even if he had been adjudicated a habitual offender, he would be eligible for parole at a 25% on a non-violent offense. And so he could still be out. And so this bill, and I know that the author is willing to work on what the final numbers are and how it's going to work, but this is something that in a group of people who didn't agree on much, agreed that the back-end sentencing measures deprive the public of what a sentence actually computes to be in the state of Louisiana.
My name is Claire Howington. I'm an assistant district attorney in the 16th, and I handle primarily post-conviction relief and appellate matters. Thank you all for having me here today. The one thing that I really wanted to talk about is just a very tiny part of this bill, but I wanted to talk about what we see as prosecutors when you talk about sentencing and parole eligibility on the back end as the appellate and post-conviction person. What I see a lot of is that people come into court regularly and they say, I took a plea. I thought that I was going to be eligible for release in 3 years, 4 years, 5 years, and it turns out that what I'm getting sentenced under and how my calculations are done, I'm going to be in here for a significantly longer period of time because I fall under a different act. I fall into a different category, and they want the judge to change their sentence. When you have a guilty plea, that is usually not something that's going to happen. However, it has happened more than once and more than 5 times that the defense attorney has come in and said, well, you know what, I actually gave the guy bad advice. I can't calculate these either. I told him the wrong thing. We thought it was going to be this particular percentage, and it turns out not to be that, and you actually end up with an ineffective assistance of counsel problem on a guilty plea, and sometimes those pleas have to be vacated, which means that you have to go back and tell the victim of these crimes that not only was what you expected going to happen in the first place, not actually what happened, but now we're going to have to start over again and either offer this person a different plea or possibly take them to trial, and that's just re-victimizing them again. So I think that having everyone in the courtroom know what happens when you take a guilty plea is a benefit for not only the victims and the DA and the defense attorney and the court and the public as a whole, but also for the defendant.
I guess the plea piece, victims aren't you guys supposed to go over the sentences with the victims?
And
Right.
I think, Representative James, how can you do that when there is a system that is so complicated that even the Secretary of the Department of Corrections can't explain it, and the computations are resulting in what we've heard here in this committee today, people being held in jail longer than they're supposed to? No one here wants people being held in jail longer than they're legally supposed to be.
So
And
so
if
what
we
are you?
prospectively fix this, that won't happen.
But so my question is, although the system is there are a lot of things about the system that I think we should fix, right? If 105 people agree with me, we'd be a lot more further, in my opinion, and I'm sure Fontenot probably feels the same way. But under the law today, it's so convoluted. What do you guys, when victims' rights are they're required to be told about the sentence? So what are you telling them today?
Well, as the post-conviction person, I don't make a whole lot of plea offers, but what I tell people is that this is the plea offer that's been made. I do not feel like I am qualified to tell you exactly how much time this person is going to spend in jail. When I make the offer right now, my expectation is that they're not going to spend that entire time in there, but calculation is up to DOC. So we'll just have to see.
Okay. And on that, with this guy, why? I mean, couldn't you guys have, couldn't it have been like a multi-bill for maybe negligent homicide on the family that came? Like what, because a lot of times, even with the fact that you guys are going forward with pleas, that tells me that you initially filed some charges that either you're probably having a hard time proving those charges, so you issue a plea. And those are conversations that you got to have with families as well, and maybe stop charging certain things if you don't have the facts to prove them, because I mean it's a lot of different factors, and it's not just the fact that the system is so hard and victims. I mean, what are you guys telling the victims now?
Well,
Representative James, I would say though that, as I just pointed out, on a negligent homicide, that person, even as a habitual offender, would be eligible for parole. At
Exactly,
25%.
and what are you telling the families? Because it seems as if you can't just tell them, look, I don't know what's going to happen. That can't be. I know that's not what you do, Ms. Barrios, because I know you very well. So I mean, you guys have and I'm not putting it all on you guys. I know your jobs are hard. I haven't had to be in your shoes, so I can't, fully speak to it, but I'm pretty sure that you guys are telling them something. I know you're not just telling victims, look, the system is so bad, we live in a state where I don't know when they're getting out of jail. I know you're not saying that. So what are you saying?
That we can't provide them any assurances on what the sentence is because it is something calculated by the Department of Corrections. And I think what Ms. Howington is pointing out is that it puts defense attorneys in a very difficult position where they may be ineffective, could face discipline with the bar if they are making certain guarantees to their clients.
Okay. Oh, yes, you do. Representative Marino.
I was trying to eat lunch so
That's
that I wouldn't
okay.
go right back to the floor again without. So how we got here is this book is so big because in Louisiana, we make a law and a sentence and a law and a sentence and a law and a sentence. Instead of the felony class system, that task force that was the recommendation of Justice Reinvestment, that's the way you go about transparency in sentencing, is you don't put every separate crime with its own sentencing rules and then amend them 25,000 times, which is why they can't calculate it. You put all the crimes into a box, and these are the set and clearly defined rules for every one of these. So when you make a new crime, you don't make a new crime, make a new sentence. You put it into the box. And it's very, very, very clear that and I even asked the question, if we had a felony class system and we made it retroactive, they could tell you today, right now, how much time everybody would serve. But no one wants to make it retroactive because we made all these promises and all these rules and all these promises to victims, and it might be slightly different. So and this bill doesn't address all the 29,000 people in jail right now. It's just going forward. The way to do it, according to the task force, is a felony class system that we started on, and it failed because we couldn't get agreement on coming up with ranges of times for things like armed robbery. This bill eliminates parole. What it's good at is putting people in jail and saying how long you will be in jail. It's not really designed to be rehabilitation. It's incarceration, so that you can know exactly how much time you're going to be incarcerated. You do know that we in this bill, you still have ability to get reductions in time. So you're not going to know exactly how much time they're going to serve, because they still can get reductions in time, which you call the back end stuff, which is the rehabilitation stuff.
It's not just the back end stuff, though. That's rehabilitation. It's the good time calculations that apply to people, regardless of that changes if you're a first offender, changes if you're a first time violent offender, a second time violent offender. And Representative Marino, at that task force, when Mr. Vining testified, they said that the felony class system would not repair those problems. That simply
the past. The ones that we already sentenced, because we're not going retroactive.
Right.
You
so
can clearly set all the rules for everything in the box. Are you parole eligible? Yes or no. Are you good time eligible? Yes or no. Can it be expunged? Yes or no. It's very, very. Other states do it. We can do it. This book would go down to about this big if we did if we did that. This is not the way to do it in the name of transparency. Not even close. That's my opinion. It's not really a question. I have to say, did you know?
You could give opinions in here.
That's my opinion.
Yeah.
And I have spent the time working on this. Way more time than my seatmate has. I promise you that.
She may disagree.
No, it's okay.
I don't think she's listening to you right now.
She don't listen to me.
Oh, she's typing notes. All right, let's bring up some of the opposition. We also had some green cards that would not wish to speak. Charles Ballet, I said his name right today. Jimmy Lestache, Stephen Tew, Penny Dorchery, Bo Duhay, Darren Ellerman, Norma DeBose, Billy Joe Harrington, and Jay Lemoyne, all present but in support would not wish to speak. So in opposition, Scotty Payton, Right on Crime, Kara Meyer, Louisiana Parole Project, and Meg Garvey, Louisiana Criminal Defense Lawyers.
Megan Garvey, here in opposition to HB 479 on behalf of the Louisiana Association of Criminal Defense Lawyers. I'm going to try to talk really fast because there's so many things that are wrong with this bill that I want to be able to fit them within my 3 minutes. But first of all, I just want to echo what Representative Marino so astutely pointed out, is that there's, even if the main goal were truth in sentencing over and above what we know about rehabilitation and fiscal responsibility, even if that were the case, there's no way that this can achieve that, right? Because what the proponents are suggesting, right, is that the rules are so Byzantine that no one can ever know what they are. So if that were the case, then how does coming in and filing a bill that just changes the percentage change that, right? There's still a calculation that needs to be done, and it's quite transparent. It's in the code book. So I just don't see how this can be suggested to really even approach truth in sentencing or change much about anything other than more than double the amount of time that people who are charged with nonviolent crimes and drug crimes spend incarcerated. That is the main emphasis of this bill. Quickly, we talked about JRI, et cetera. This bill, despite the stated intent of the representative, it does turn its back on the bipartisan work, on all the thought was put into that. It does turn its back on the fact that we've saved over $30,000, that we've reduced our prison population by, I think Mr. Lambert gave a number, but the information that I had is like almost 30%. So it does turn its back all that. But fiscally speaking, right, $67.44 a day to keep somebody in jail. Let's talk about a 5-year sentence, right? Under the current law, somebody with a 5-year sentence is going to cost us $43,000. Under this law, they're going to cost us $104,000. That's $61,000 difference, right? That's a huge amount of money. Given where we are at with our economy and with education levels in this state, that is a lot of money that could go to really helping lift our people up, that is just being sucked away to keeping people in prison. Finally, parole. This takes away parole. You know what parole is? Parole is an opportunity for people who have been incarcerated, which is under the best warden, under the best system, an inhumane and difficult place that people operate under different rules in prison. And it takes a significant amount, and I believe there are people here who can speak to this better than me, but it takes a significant amount of transition and support for somebody to successfully transition from being incarcerated to being out in the community, living a productive and healthy life, right? So as it currently stands, people have assistance through parole. They have people that help make sure that they stay on the right path, to help make sure that they have access to services that they need, and to make sure that they are working and have access to those kinds of opportunities, and the parolees pay for that supervision. And so I do ask that this committee vote down this bill. I think it's fiscally irresponsible, and I think it's just contrary to all the work that's been done and everything that we've learned about what it takes to make our community safer. And I mean, one of the proponents, Mr. Lampert, even heralded the success of JRI. So why are we going to turn our backs on this? And then I also echo what Representative James asked, is that, we have these people that come in who have been irreparably harmed, right? Traumatized, and my heart goes out to them. It's terrible. But the stories that we hear about what happened to them don't really have anything to do with what the bill does. They have to do with communication between prosecutors. They have to do with law enforcement choices. There were many opportunities in that particular scenario where things could have gone differently. And I just want to make sure that, while we do have tremendous sympathy for people who have lost somebody to a crime, that we don't allow that to cloud our vision of what's actually taking place and what is actually contained within the bill. So thank you.
Thank you, Ms. Garvey.
Thank you, Mr. Chairman. Kerry Myers, the Deputy Director of the Louisiana Parole Project. And no matter how well-meaning this bill might be, I think it is regressive, and I certainly don't want to just repeat what everyone else has said. But I'd also like to point out that just educating judges is not sufficient to compensate for the difference in the current sentencing laws. We say we trust judges, but not necessarily. I don't think we do. Because we mandate judges in so many cases with mandatory sentences. If we trusted judges, they wouldn't be mandated to sentence people to mandatory life without parole. We would give them discretion in certain cases, but we don't do that. So we obviously do not trust judges to do their jobs on a case-per-case basis. I also think that parole incentivizes rehabilitation. Because it's a very difficult thing to go before a parole board and put your record in front of a parole board. I work with parolees on a daily basis, people who are candidates for parole, who go up before the parole board, and they have to show demonstrable records of rehabilitation to be granted parole. That's an incentive. If we take that away, we make a one-size-fits-all bill, they can sleep in their bunks for 5 or 10 years, and somebody will kick that bunk and say it's time to go. They have to do nothing. We have a determinate sentencing system. We actually went away from indeterminate sentencing 30 or 40 years ago because we believed that it worked better. In this particular case, it's going to disincentivize rehabilitation, and so I would believe that right now this bill is the wrong bill.
Thank you. Mr. Payton?
Good afternoon, Mr. Chairman, committee members. My name is Scott Payton. I serve as the State Director for Right on Crime. Right on Crime worked diligently with legislators and criminal justice stakeholders to help pass the 2017 reforms. I also serve as a member of the Justice Oversight Council. While Right on Crime is concerned about a number of the policies in House Bill 479, not least of which is a significant increase in Louisiana's prison population and financial cost, without offering a commensurate public safety benefit. With that said, I'd like to thank Representative Villio for bringing this bill, as this is a conversation that remains critically important. Actually, this conversation took place in depth with the Justice Reinvestment Task Force and the bipartisan effort around the 2017 Justice Reinvestment Initiative. I would like to respectfully disagree with Mr. Lambert. This does not build upon the 2017 reforms. If that were the case, then Pew Trust would not be against this bill. Additionally, if we start with transparency, there's 54,000 individuals on community supervision. Parole represents 5% of that amount. 40% are diminution of sentence. So it will not significantly reduce the number of parolees. It may reduce the length of time that the good time diminution sentence people are serving, but cutting out parole alone is only 5%. As a former probation and parole officer, this bill is not friendly to probation and parole officers. It is going to create more work for them on the back end because offenders will not take the opportunity to receive the programming because incentives will be gone. I know for certain if you have a DOC number, you can calculate time. If they can calculate time, DOC should be able to calculate time. The reason why conservatives are involved in criminal justice reform is exactly what's been brought up about this bill. The system's broke. It's time that conservatives hold the Department of Corrections, hold the judiciary, hold prosecutors to the same standard that we hold any other institution, any other government agency. And that's what is happening here. The system is broke. We're not fixing it. But we're doing it at the expense of the people that are having to go through the system. And I'd like to bring up too Florida. Texas wasn't mentioned. Texas did this back in 2007. They've closed 7 or 8 prisons, and their crime rate is half that of Louisiana. In Florida, Florida is infamous for their mandatory minimums. A study from James Madison Institute, a conservative Florida-based think tank, in conjunction with FAM, found that Florida spends more than $100 million annually incarcerating drug offenders serving mandatory minimums, undermining the argument that mandatory minimums have a deterrent effect. The report noted that the overall drug-induced death rate in Florida increased by 150% in the 16 years between 1999 and 2015. Truth in sentencing or transparency in sentencing is often synonymous with mandatory minimum.
30 seconds.
And it's a policy regime promoted by the federal system in the 80s and 90s. And the First Step Act was actually the federal government taking the example from the states and implementing that on the federal level. Over-reliance on incarceration has not led to a safer state. I was a probation officer. I worked in 2017 when these reforms came into effect. I see how earned compliance credits work, which is basically the good time for probationers. And that incentive encourages positive behavior and in the end helps to reduce recidivism.
Thank you, Mr. Payton. Representative Marino for a question.
Yeah, thank you. First thing I want to say is I just want to apologize to my seatmate. I'm getting a little out of control with, I don't mean to attack you in any way, even though I don't like the bill. It's not, it's not professional, and I apologize. With regards to that last point, Mr. Payton, as a probation and parole officer, do you think there's any value to releasing people when they get out of jail and having zero parole supervision, just releasing them and then they're out?
Absolutely not, Representative Marino. That is the job of probation and parole. It's dollars a day to supervise somebody under parole, but the reentry efforts, helping them to get employed, helping them reintegrate housing, transportation. As a probation officer, I dealt with all sorts of issues and complications, and we wore many hats.
So under this bill, though, what we're doing is we're just saying you're just going to serve 85%, and then you get out, and you are not on parole. So as soon as you get out, you're basically on the street. Is that going to help with recidivism, or is that going to what is that going to do with people's ability to stay on the right path?
It's going to increase recidivism. It's going to drive more people back. We already have a difficult time dealing with recidivism, and the Department of Corrections has been working over these last few years since 2017 with the savings and the reinvestments to work with community partners like United Way and Goodwill to help with employment. Right on Crime has been working with employment. These services are much needed for the individuals that are exiting from prison.
And if they tell you that, well, probation and parole aren't able to supervise adequately right now, we're still operating on the premise that, or under the actual reality that they're still supervising way more than they're supposed to be because we haven't gotten the numbers down right. Correct?
Absolutely. When I left 3 years ago, I was supervising over 140 quote-unquote violent offenders. And all it takes is for one person to get arrested, and you're spending weeks of paperwork and time. The caseloads have dropped, but they're still much higher than a national average.
Thank you.
Representative Bacala.
Thank you, Mr. Chair. You know, we talk about numbers, and I think coming from Appropriations Committee and Retirement Committees, numbers are important, and getting them right is important. So many times you sit in here in this committee, and I hear people say, you know, we have people incarcerated in prison for 20 years for marijuana. As a matter of fact, not long ago, I was on the elevator with an inmate, and that was his exact scenario, I think. I think he said 20 years marijuana. Well, you dig a little deeper, it's 20 years for 7 pounds of marijuana, so it doesn't sound quite as unreasonable, but it still sounds excessive. But the truth of the matter is, he's really probably, if it was truth in sentencing, he'd be saying, I'm serving 7 years for 7 pounds of marijuana. Because that's the effective sentence. So every time we sit in here and we hear these excessive sentences, somebody ought to say, well, let's wait a second. Let's find out with the good time. What is the real time these people are going to serve, instead of assuming and sounding, so horrible about how we're incarcerating people for these long periods of time, excessive sentences, when in fact they're not real. Don't we think that's important, to know the truth? Let me give you, we had a personal story. I'm going to tell you a personal story. February 10th, 2010, I had to go tell my wife that her mother, father, and brother were killed in an accident in Metairie. It was a reckless driver. Eventually, 40 years later, many court dates, every one of them traumatic. She was sentenced to 3 years. She filed an appeal and was put on house arrest, so I doubt there was ever a day served. Because once you diminish the sentence for someone who's probably sat around for a year and a half on house arrest, getting credit as though they're in prison, it really don't mean much. Now, honestly, she was forgiven by me and my wife. So I didn't have a deep desire to see that she served time in prison, because it was an accident, even though she was convicted of negligent homicide. But there's nothing less truthful than sentencing in this state. It's a lie. It is time we have truth. It is time the people hear the truth. And it's time we get this. What you say is what should be. 20 is 20, 6 is 6, 5 is 5. But we play with the numbers and we make it sound like we're the most unethical, cruelest state in the world. And I'm sick of it. So, Mr. Chair, I move favorable on this bill at the appropriate time.
Thank you. Katie Honey Lowry, Will Harrell, and Cameron Westbrook, all in opposition, would wish to speak. And everyone waves. I have it. I can see. I got you. Chico Yancey. White cars are last, but I will get to them.
Go ahead, Cameron.
Thank you, members. I'm going to keep this pretty brief. I think most of what I wanted to say has already been said. I'm Cameron Westbrook. I work for Americans for Prosperity, Louisiana. We're a center-right organization that focuses heavily on removing barriers to people reaching their full potential in the state. And you've seen us work a lot on issues like tax reform and occupational licensing reform and that. We've taken an interest in this set of issues because we see one of the greatest barriers that people face is often the criminal justice system. And I wanted to kind of break down a few things. This bill, I'll be completely frank, it's probably one of the scariest bills I've seen in quite a while. The concept that we're going to be removing parole, something that is essential to ensuring that people are more likely, at least, to be able to re-enter society and not reoffend, that's a bit scary to me. Additionally, when it comes to, there was a fiscal note on this bill, and it said that it was indeterminable, unless there was a new one that I'm unaware of. Indeterminable because we don't know how many people are going to be sentenced as of after August 1st. I don't know how many either, but what I can say is that when we look at the amount of time extra that people are going to see, we go from 35 to 85%. I did some calculating. That's probably an additional 22,000 and some change for just in the parish jails because the rate is a little lower per day. Because that's an additional 913 days for a 5-year sentence. So right there, we have a group right now that's helping work to crunch the numbers and get a more realistic idea of how much this is going to cost the state. And I'd love to share that with you whenever we have it. But I want to make it very clear, when we talk about fiscal responsibility, and this isn't just bad from a fiscal angle, there are other reasons, and I'll get into those, but from a fiscal responsibility angle, when we talk about making sure that we have the funds to do the necessary things. Back in 2017, a broad group of organizations and people across the political spectrum joined with the district attorneys, and they got together and they agreed on some things. And one of the things they agreed on was, one of the problems that we have is we have the highest incarceration rate in the country. In the world, some may say. And I don't know if it is right now. It kind of depends on the day. We're battling with Oklahoma, but it's still very, very high. We agreed on that. And we also agreed that longer sentences don't deter crime. There's a million reports that disagree and that agree, but that's something that we came to that conclusion. We said something needs to be done. I had a quote from the former executive director of the LDAA, but I don't have it here. It's on my laptop. So we saved, after 2017, in 2018, I believe it was $12.2 million, $18 million in 2019. Those are the savings that I'm not willing to let go of, especially if those savings come along with reinvesting that money in programs that actually make people less likely to recommit crimes. That's something that we wouldn't want to see. It goes directly in the opposite direction of what we did in 2017. And I respect the bill author, and I respect, that she says the intent is not to go backward on the 2017 reforms, but just looking at what it's going to be, I'm very, very skeptical of that. Additionally, what was it? You
gotta wrap up.
Sure. Yeah. The idea that we're going to be, we're actually going to be saving money because judges are going to be giving lower sentences because we have a more realistic idea. That assumes that judges, all judges just give sentences based on, well, this is what I actually want to give you. I would venture that there are judges who know that the purpose of things like good time in jail is to incentivize good behavior and rehabilitation. So I ask you to vote no on HB 479.
Good afternoon. My name is Katie Hunter Lowry. I'm the crime survivor organizer with the Promise of Justice Initiative. I coordinate the Louisiana Survivors for Reform Coalition. And my heart is with all the families here who have lost someone and were failed by the system. Survivors are not a monolith, and every person's needs are different. I talk to survivors and victims' loved ones on a daily basis, and there's one thing I hear over and over again: the criminal justice system does not help survivors heal or provide real accountability. I am a survivor of violence many times over, and I am deeply opposed to this bill. This concept does not make us safer. Louisiana sentences people to LWOP at the highest rate in the country, and it does not deter crime, which is actually a point that Representative Fontenot made last week when discussing the road users law. I have been abused, beaten, spit on, punched, attacked, and raped. I've been 20 feet from a young woman while she was shot to death at point blank range. The criminal legal system has never offered me services or support to keep me safe or recover from these traumas, or to prevent them from happening again, and this bill doesn't offer those things. It is really frustrating when lawmakers and the District Attorneys Association says that this kind of proposal is in service of victims because it is for the state. When survivors talk about wanting solutions outside a carceral system, we are often ignored. And grief is not a linear process, and I have not, nor do I intend to forgive the people who have deeply damaged me. But I can say for sure that what was taken from me when I was victimized cannot be healed by so-called transparent sentencing. I understand the difficulty for this body and for us all in not knowing how to care for victims. We have to use trauma-informed approaches, which includes providing information, following up, and setting boundaries. The DAs have said they need this bill because their jobs of having honest conversations with victims are too hard, and that they want to make promises to families. But the truth is that you owe it to us to provide more realistic and consistent updates. And the truth is also that you don't have to give a survivor everything they ask for. You know, I can say to you, Representative Godot, I want you to help me kill the men who raped me. And you can say to me, I know that you're angry and hurting. I will walk with you through this pain, and I can't do what you're asking. It is okay to say to victims and their loved ones in the legal process, I can't make you a promise that we will put, other humans in cages until they die. Here is the support I can offer instead. And programs like Louisiana Victim Outreach under Francis Abbott in Pardon and Parole are doing incredible work, reaching out to survivors in advance of parole hearings, offering clear communication and therapy. You know, the idea that this bill has a fiscal note of zero is incredibly outrageous when we've heard multiple times today how expensive incarceration is. The Crime Victims Reparations Fund is appallingly underfunded and could use this money. We believe this bill is a deeply misguided rollback and not the best that we can offer survivors and victims' loved ones. Thank you.
Thank you.
My name is Checo Yancey with Vote. In a perfect world, we could have transparency. But I thought we were trying to do something in 16 and 17 to at least get to an honest road to be able to tell victims, to be able to tell the judges, to be able to tell the prosecutors, if I owe you $10, 65% of that, we know what that means. 85%, we know what that means. And I heard Representative Bacalot, who I have a lot of respect for him, because one thing that I know about Representative Bacalot, he's going to speak his mind, and I can respect that. But this is a reckless bill because it doesn't stand for helping people to become better people. You know, when I testify, I tell people I've been to prison, and I can remember the Criminal Code of Procedure because I worked in the law library for 18 years. I can remember the Criminal Code of Procedure being about this thick, where you could understand if you had your sentence, what it was going to be. I can remember working in the law library and when the Department of Correction would send Mr. Henry Goins to teach the inmate councils to help calculate good time. There was only one person in DOC that could calculate good time. What happens when the man or the woman goes to Caddo Parish or goes to one of the private prisons that nobody there can calculate the time? Is it going to be transparent? If I owe you $10 and you tell me I only have to pay 85% of that, guess what? We all gonna know what that's mean. But if the judges put their 2 cents in, you tell the victims one thing about the $10. By the time we finish it, then we end up with pages that thick when you're taking out a loan. This is a terrible bill. I cannot understand what's going on because I heard that reform is working. Some people don't like the reform. So now we're going to take it back and kick it back. You guys have done too much work here. Too much work to help reform the system, to help make it a better system. You know, I heard somebody say, you know, if we do this, it's going to be transparent and the victims and everybody's going to know what's going on. Well, if you took it away from the judges and you take it away from the prosecutors, that if somebody do something, how are they going to tell them if the time is not calculated correctly? There used to be about a dozen good time laws from 1979 up until now. I guarantee you, ladies and gentlemen, on this committee, if you look at the Criminal Code of Procedure, there are now a dozen good time bills that nobody can understand. Florida, Texas, everybody, like I heard Representative Bacalard say, somebody on the elevator said he got 20 years. If he had 100 pounds of marijuana, he got 20 years. But what is his good time? What is his good time? And nobody can really say that. This bill is a terrible bill, and I would ask this committee that I respect, that's trying to do the right thing at the proper time, to kill this bill right where it is. Kill it.
Thank you, Mr. Yancey. Representative Bacala.
Mr. Yancey, great deal of respect because you always speak your mind too. But I did want to make mention one thing. We can talk about victims and them understanding what the consequence of the offender is. But I think as Representative Villio spoke to earlier, how about the person who's pleading guilty and may not have a clue if he's going to be doing 10, 15, or 20? So I think the other part of this is it gives the person who's contemplating a guilty plea a better idea of what the reality of their sentence is, because as was stated earlier, you have defense lawyers who can't figure it out, so they're just saying, well, you know, I'm not sure. So doesn't truth in sentencing also benefit those who are contemplating guilty pleas based on offers?
Well, I don't even want to get into guilty pleas because sometimes when you plead guilty, you've been sitting in a jail for 90 days. You haven't seen your attorney. You haven't seen anybody. COVID is in the prison and in the jail. And guess what? You may take a plea deal and thinking it's one thing, but you haven't told the victim that this guy's going to take a plea deal.
Yeah,
the victim now, you didn't really you have missiled the victim, Representative.
Yeah,
so therefore, the plea deals, when you talk about plea bargaining, think about what you're saying. A man sitting in prison for 6 months and an indigent offender person that's handling 150 cases. If he come and say, I've talked to the DA, and the DA say, if you plead guilty today, you can go home. That guy and the victim has not discussed the truth sentencing.
Yep.
They have not discussed it. So therefore now, you're not doing a truth sentencing. You're just making a plea deal to clean out somebody out of the prison, sir.
I think you and I are on the same page. We might look at that from a different angle. The only thing I'll disagree with you on, most of them guys have been sitting in jail for 365 days and decide to take their plea deal.
365 days, think of this, Representative Bacalard. With the sheriffs involved and you were involved in the reform and we did this and everybody came to the table. Everybody, someone like me that's been to prison, spent 20 years in prison, we came to the table to talk about trying to do the right thing for the state of Louisiana. And now we coming back 2021 and we want to change everything. When first of all, we've not straightened out the sentencing for the guys in prison right now, and you're talking about you going forward and you're going to change it. This is reckless. I mean, think about it. But I still owe you that's $10 now, remember. I said $10.
6.
Is it gonna really be 6? Because let me borrow 10 now, and I'll give you 6 back. Thank you.
Thank you. I mean, for the criminal defense attorneys, I don't think we have trouble letting our clients know what. I mean, I do it every day, so, but maybe something different. We also have some red cards. Chico spoke. Jennifer Harding vote. Kelly Garrett vote. Bruce Riley vote. Consuela Gaines vote. Vanessa Spinazzola. Liz Mangum, Smart on Crime. Amy with Operation Restoration. Jacqueline Germany vote. Stephanie Willis, ACLU. Michael Cahoon, The Promise of Justice. Tom Costanza, Louisiana Conference of Catholic Bishops. Terry Landry Jr. Rachel Gasser. Chris Kaiser. Dan Kreutz. Rodney Braxton. Peter Robbins Brown. Telly Medina. James Lee. Melissa Flournoy. Christian Rhodes, Ryan Roberts. We also have President would like to speak to give information. Judge Jules Edwards.
Good afternoon, Chairman and Representatives. I am Jules Edwards, a retired state court judge, and I am here only speaking for myself, and I want to provide you with some context to where we are. I'm going to also say I'm actively involved in Lafayette in implementing the Department of Corrections prison reentry regulation, and I need to understand the significance of that. So, first of all, bottom line up front, the authors suggest that they are here to provide transparency, and several of the folks in favor, the proponents, have asserted that variously today they don't know how to calculate. And they also say they do know how to calculate. It's just that when we announce the sentence is announced as a high number, but when you account for good time, it ultimately ends up a low number. So it can't be both. They can't not know how and know how, right? But the solution to this would be to give the Department of Corrections the resources necessary to create a web-based good time calculator so that everybody could go to the website and calculate the time before the sentence is announced, before the plea is negotiated. Everybody would have that information. But in any event, that's not where we are. I need to provide some information about the context here. Several years ago, this legislature adopted the Justice Reinvestment Initiative, which was to change the amount of time folks would serve in prison to capture some savings that could be reinvested, right? That then transitioned to the Department of Corrections Prisoner Reentry Initiative, which was the Department of Corrections looking out nationally to see what the evidence-based practices of corrections are and adopting them. And that recently got translated into the Prisoner Reentry Regulation, which we're in the process of implementing now. And all of those three phases were based on the evidence that simple time in prison does not deter others from committing crime. So if I see you get a long sentence, that doesn't deter me from committing crime. And simple long sentences does not motivate the person serving that time to desist from committing future crimes, right? There's a whole body of evidence of what needs to be done, and that's what was adopted in the Prisoner Reentry Initiative and Regulation. And that requires us, and what we are currently doing, is when a person is incarcerated, comes to a state facility, there's a risk needs assessment that is done, and then they determine what sort of programming would assist the person to desist from criminal conduct once they are released, and encourage that person to consume those rehabilitative services and programming while they're incarcerated. That's the first phase. The second phase is when they're preparing to be released on parole, then folks in the local community assemble together to see what sort of programming the person has consumed, where they are now, what programming they need to consume, and is that programming available in the local community? And then folks go into the prison and communicate what's available and encourage them to buy into that. I want to participate in that. And then when they are released, they're released with a program of services that they're going to consume while they are released that are designed to encourage encourage that person to desist from future criminal conduct. And all of that, the incarcerated person has bought into, and thus, because that person has bought into it, they own that plan, and they're intent on executing that plan. That is what is in place now. This bill takes that away, goes completely away from that. If that is your choice, that's what you want to do, pass the bill. If you want to keep Louisiana on the approach that we are using evidence-based policies and practices and procedures, then this bill, voting in favor of this bill, would not move you in that direction. Hopefully I've been brief. I can answer the questions.
Thank you, Judge. We don't have any questions for you.
Outstanding. Thank you very much. Have a blessed day.
Representative Villio, to close on your bill.
Thank you, Mr. Speaker, members.
I think Representative Marino has a question on closing.
Quick, with all due respect, the Criminal Justice Reinvestment Task Force, all the concerns that you laid out about not knowing the clarity in sentencing, it's clearly spelled out in their report that their recommendation, with 21 different people participating, is to implement a felony class system to eliminate inconsistencies in sentencing and release. And I'd be real glad to sit down and walk you through what all of that means and work with you on it.
Thank you, Representative Marino. I've worked with you for 30 years. We've been on the opposite side of the courtroom. We're good friends, but nothing changes on my bill. I appreciate you. Mr. Chair, members, as for the last speaker, the bill changes nothing about nor inhibits the reentry initiative whatsoever. As for the former parole officer, the data refutes what he testified to. This bill will reduce the caseload by 40% and does not jeopardize public safety because the data shows that the recidivism rate for good time release and for full time release is the same. As for the opposition by some, did you hear the testimony on House Bill 603 earlier this morning about how the system is broken by those same people who oppose this bill? And I'll tell you why. Because it's about the author. They believe I'm tough on crime, and they don't trust me. I am tough on crime. I'm proud of that label, and I will continue to wear it. But what I commit to you, and what I know each of you know, is that my word is good. And I commit to you that I will not take this bill to the floor if I cannot satisfy you that this bill will not repopulate the jail system. I ask for your favorable passage.
Thank you, Representative Villio. Representative Marcel, there's already been a motion.
I was just going to ask her.
Oh, yeah, question.
We're back to questions.
Yes, ma'am. I was just going to ask you. Were you gonna
she
turn
has
it to
closed. Will you take a question on closing?
Okay.
She said yes.
Oh, I'm sorry. I was just going to ask you, is your intention to turn this into a study resolution? Is that your intention?
If I cannot satisfy everyone, if I cannot satisfy you.
You say everyone who's a.
Well, I'm talking about if I cannot satisfy the members of this committee, and I am going to work hard between now and the floor to show you everything to satisfy you, then I would have no choice to do that. Okay. But you have my word. I'm not going to take it to the floor if I cannot satisfy you that this bill will not repopulate the prison system, because that is absolutely not my intent.
Oh, I understand. I was just wondering if you would consider just turning it into a study resolution without the bill passing.
I appreciate that, Representative Marcel, but I'd like to go forward with my bill.
Thank you.
Thank you.
Thank you, Representative Marcel, and thank you, Representative Villio. Representative Bacala has made a motion to report the bill favorable as has it been amended? As amended. Is there any objection? Representative Marino objects. Madam Secretary, please call the roll.
Representative Bacala? Yes. Yes. Representative Bryant? Representative Fontenot? Yes. Yes. Representative Gutto? Yes. Representative Jones? Representative Marcel? No. No. Representative Marino? No. Representative McKnight? Yes. Representative Muscarello? Yes. Representative Nelson? No. Representative Seabaugh?
Yes.
Yes. Representative Villio?
Yes.
Yes. 7 yeas, 3 nays.
7 yeas, 3 nays. The bill has been reported favorable
Thank you.
with amendments.